Craig Williamson Pty Ltd sold drapery, clothing and furniture from their store in central Melbourne. Barrowcliff was the head of their advertising department. Advertisements for the daily newspapers were prepared and then stored in a large book known as the advertising book. The contents of the advertising book were therefore crucial to the business. We're not told why, presumably there was a breakdown in the employment relationship, but Barrowcliff went into the advertising book and cut out from the book several pages of advertisements, which, it was said, would cost £50 to replace. The store sued for the return of the pages under Section 59 of the Justice Act 1890, which allowed such an action by any person claiming to be entitled to the property or possession of any goods. The lawyers for Barrowcliff responded that the pages in the book were not goods, and as a result the action must fail. So the case came down to statutory interpretation. Justice Hodges had to determine whether the pages could be goods. He said, "Now I think it is a fundamental rule of construction that any document should be construed as far as possible so as to give the same meaning to the same words wherever they occur in that document, and I think that would apply to an Act of Parliament. There ought to be, in my opinion, very strong reasons for saying that words in one part of a section mean something different from the same words in another part of that section." Relying on that rule, he looked elsewhere in the same section and found that the section also empowered the justices to deal with actions for goods and chattels bargained and sold, for goods and chattels sold and delivered. He then found that because the book and the pages inside the book with the advertisements on them were certainly things that could be bargained and sold or sold and delivered, it must follow that they were goods. And if they were goods for that part of the section, then they must be goods for the whole section, meaning that the store, Craig Williamson, could claim to be entitled to the property or possession of any goods. The record doesn't tell us how the matter ended up, but the case teaches us that words should be given the same meaning throughout an entire piece of legislation.